My daughter-in-law told me I couldn't babysit them anymore. I was sitting in my living room in the quiet suburb of Cary, North Carolina, the afternoon sun cutting dusty stripes across the worn carpet, when the text came. It was brief, stark. We've decided it's best if you don't watch the kids. We'll find other arrangements. No explanation. No discussion. Just the cold, clean cut of it. It felt like a fist in the stomach. I had been watching Lily and Tom every Tuesday and Thursday for 3 years, ever since Lily was born. It wasn't just babysitting. It was connection, routine, love woven into the fabric of my week. We had our rituals, making special pancakes with extra blueberries on Tuesdays, building elaborate blanket forts that took up the entire den on Thursdays, reading the same worn copies of Goodnight Moon and Where the Wild Things Are until they fell asleep on my lap. My son, Mark, my only child, had always seemed grateful for the help, for the bond I shared with his children. His wife, Sarah, had been polite, distant perhaps, but never openly hostile. This text was an abrupt, brutal change in the landscape. My hands trembled slightly as I reread the message, the words blurring for a moment. I felt the sudden, terrifying void opening up in my future, the sudden silence where small voices and laughter used to be. It wasn't just the loss of childcare duties. It was the severing of a vital link to my grandchildren, a link I had cherished above almost everything else. If you've lived through something like this, let me know where you're watching from. I'm genuinely curious who else this resonates with. I sat there for a long time, the phone heavy in my hand. The silence of the house pressed in on me. It was a silence that suddenly felt permanent. I looked around the room. Toys were still scattered on the floor from their last visit. A plastic dinosaur half hidden under the armchair. A small, brightly colored block near the fireplace. They were innocent remnants of a life I was being told I could no longer be a part of. It felt wrong. Fundamentally wrong. It wasn't about inconvenience or finding another sitter. It was about a line being drawn, a wall being built, and me being deliberately left on the outside. I thought about Lily's latest drawing she had proudly presented to me, a scribbled portrait of our family, me included, taped to my refrigerator door. Would there be more drawings? More messy handprints on my windows? The text message seemed to say no. It was an erasure, a dismissal of my role, my history, my love. I tried to call Mark. It went straight to voicemail. I tried Sarah. Straight to voicemail. I left a carefully worded message for Mark, asking him to call me, that I was confused and upset by the text. I didn't mention Sarah directly, not wanting to escalate things immediately. I waited. The minutes stretched into an hour, then two. No call came. The silence deepened, filled only by the tick-tock of the grandfather clock in the hall. It was a sound that usually comforted me, a steady presence. Now it felt like a countdown to something unknown, something worse. I walked to the kitchen. The counter was clean, the dishes put away. Sarah was meticulous about order, about control. Every visit had parameters. Don't give them too much sugar. Make sure they nap at exactly this time. Screens for only 30 minutes. I had always complied, biting my tongue, wanting only to have the time with the children. My own mother had been a constant, loving presence in my children's lives. It was a given, a natural extension of family. This felt unnatural, a deliberate disruption of that connection. I ran my finger along the cool granite countertop, thinking about the meals I had prepared for Lily and Tom, the cookies we baked, the small, everyday moments of joy. Were those moments worth nothing? Had they meant nothing to Sarah? Had they meant nothing to Mark? The question hung in the air, heavy and suffocating. I opened the refrigerator. Lily had helped me put away the groceries the last time, her small hands fumbling with the milk carton. I closed the door quickly, unable to bear the sight. My eyes fell on the bulletin board near the phone. Pinned there were photos of the children. First day of school, Halloween costumes, a blurry photo of them on my lap reading. These weren't just pictures. They were proof of a relationship, a bond. The text message felt like a tear running through the middle of those photos. I needed to understand. I needed to hear it from Mark, but he remained silent. His silence was as loud, perhaps louder than Sarah's text. It spoke volumes about where his loyalty lay, about his inability or unwillingness to intervene, to defend my place in their lives. It was another betrayal, quieter but deeper than the first. I felt a familiar ache settle in my chest, and old pain resurfacing. The feeling of being disposable, of being easily replaced. Sarah had always seemed to view me through a transactional lens, helpful when needed, easily set aside when not. I had seen it in small ways over the years. My advice ignored, my presence tolerated, rather than welcomed at family gatherings, decisions about the children's lives made and announced without consulting me, even on things that directly involved me. But this was different. This was a complete severing. It felt like a deliberate act to erase me from the children's daily lives, to control their access to me entirely. The sun had moved, the light shifting, casting long shadows across the room. The house felt colder now, empty. The future I had envisioned, filled with weekend visits, holidays, watching them grow, suddenly seemed fragile, distant, possibly unattainable. I walked back to the living room, sat down, and picked up the phone again. I stared at the text message. We've decided it's best. Best for whom? Not for the children. I was certain. They loved coming here. Not for me, obviously. Best for Sarah. Best for her control. Her need for everything to be exactly as she dictated. The quiet rage began to stir within me. A slow, unfamiliar heat. It wasn't loud or explosive, but a deep, simmering resentment. I had given so much. My time, my energy, my love, and it was being discarded so easily. I thought of all the times I had rearranged my schedule, canceled plans, driven through traffic, all to be there for them, for the children, for Mark and Sarah. All the times I had swallowed my opinions, kept silent when I disagreed with a parenting choice, just to maintain the peace. It hadn't mattered. None of it had secured my position. The thought was devastating. I wasn't just hurt, I felt a profound sense of injustice. It wasn't about convenience. It was about dignity, about my inherent right as a grandmother to be a part of my grandchildren's lives. This felt like a fundamental violation of that right, a right that was being denied by someone who had married into the family, someone who didn't understand the depth of the bond, the history. I looked again at the text. It was a wall, and I had to decide if I would accept being on the other side of it. The silence stretched into days. Mark didn't call back. My message went unanswered. Sarah didn't respond to my polite, carefully worded text asking for clarification. It was as if they had vanished, taking my grandchildren with them. My Tuesdays and Thursdays became empty spaces on my calendar, vast stretches of time that had previously been filled with the delightful chaos of young children. I tried to fill the time. I went grocery shopping, did yard work, read books, but every activity felt hollow, overshadowed by the absence. I kept checking my phone, hoping for a call, a text, anything that might explain or soften the blow. Nothing came. The radio played softly in the background, but I barely heard it. My thoughts were consumed by the last time I saw Lily and Tom. It had been a week before the text. We had gone to the local park, Hemlock Plaza, and they had run giggling across the grass, chasing squirrels. I remembered helping Lily climb the slide, the feeling of her small hand in mine. I remembered pushing Tom on the swing, his joyful squeals reaching the sky. These memories, once sources of comfort, now felt like sharp pangs of loss. It wasn't just the big moments I missed, it was the small, quiet ones. Reading bedtime stories, tying shoelaces, sharing a snack at the kitchen table. These were the moments that built the relationship, the foundation of love and trust. Sarah's text had effectively dismantled that foundation. I walked through the house, the quiet amplifying my sense of isolation. In the den, the blanket fort was gone. I had carefully folded the blankets, put away the pillows. It had felt like dismantling a monument to my time with them. The plastic dinosaur was still under the armchair. I picked it up, turning the hard plastic over in my fingers. It was a Tyrannosaurus Rex, Tom's favorite. He liked to make it roar. I imagined his little voice, the sound that I might not hear for a long time. It was unbearable. I put the dinosaur on the mantelpiece, next to a framed photo of the children. It felt like a small act of defiance, a refusal to erase their presence entirely. The injustice of it gnawed at me. I had been a good grandmother. I had been reliable, supportive, loving. I had respected their rules, their boundaries, even when I privately disagreed. I had never interfered with their parenting decisions, never undermined Sarah's authority. I had simply been there, a steady, consistent source of love and care for the children. Why was that being taken away? What had I done? I replayed every interaction, every conversation, every look Sarah had ever given me. Had I missed something? Had I unknowingly crossed a line? The uncertainty was tormenting. It wasn't just the denial of access, it was the implication that I was somehow unfit, somehow harmful to my grandchildren. The absence of explanation made it worse. It allowed my mind to conjure up possibilities, each one more painful than the last. Had Sarah told Mark something about me? Had she exaggerated a minor incident? Had she simply decided she no longer wanted me involved and convinced him to go along with it? His silence was the most hurtful part. My son, the person I had raised, the person whose life I had dedicated myself to, was either unable or unwilling to stand up for me. It felt like a complete abandonment. I remembered a conversation with my friend Carol a few months ago. We were having coffee at the Panera Bread near the mall. I had mentioned casually that Sarah was very particular about the children's schedule and diet. Carol, who had several grandchildren of her own, had nodded sympathetically. Some daughters-in-law are like that, she had said. They want to be in complete control. It's tough. At the time, I hadn't thought much of it. I had dismissed it as typical generational differences, a new mother's natural protectiveness. Now, Carol's words felt prophetic. It wasn't just protectiveness, it was control, and I was seen as a threat to that control. Unpredictable element in her perfectly ordered world. The thought solidified my resolve. I couldn't let this stand. I couldn't let Sarah dictate whether or not I had a relationship with my grandchildren, especially not without a valid reason. It wasn't just about me, it was about the children. They deserved to know their grandmother, to have that connection. I thought about the legal concept of grandparent visitation rights. I had heard of it vaguely, seen news stories some. It had always seemed like something that happened to other people in contentious divorces or tragic circumstances, not something that would apply to a seemingly stable family in a quiet suburb. But what Sarah had done felt like a hostile act, a deliberate attempt to sever a familial bond. Was that enough? Was her personal preference enough to justify taking my grandchildren away? I didn't know the legal specifics, but I knew instinctively that it felt wrong, deeply wrong. I started to research online, typing phrases like grandparent rights, visitation, North Carolina law. The results were overwhelming. Legal jargon, case summaries, statutes, it was complicated. But the core idea seemed to be that in certain circumstances, grandparents did have rights. Rights that could be upheld by a court, even against the wishes of the parents. This was a ray of light in the darkness, a possibility I hadn't fully considered. It would mean conflict, open, legal conflict with my son and his wife. It would be painful, messy, and public. It was the opposite of the quiet life I preferred, the opposite of the peace I had always sought to maintain within my family. But what was the alternative? To simply accept the banishment? To let Sarah erase me from my grandchildren's lives? To sit by and watch them grow up from a distance, if I was allowed any distance at all? The idea was unbearable. The silence of the house felt heavier now, filled with the weight of this potential conflict. The soft glow of the computer screen illuminated my face as I read, absorbing the information. It was a daunting prospect, but the alternative felt like a form of slow, emotional death. I closed the laptop, the click echoing in the quiet room. The decision wasn't fully formed, but the seed had been planted. I wouldn't be erased. I wouldn't be dismissed. Not without a fight. The clock in the hall ticked on, measuring the seconds, the minutes, the hours of my solitude. It was no longer just counting time. It felt like a drumbeat, marking the approach of something inevitable, something difficult. I stood up, walked to the window, and looked out at the darkening sky over Cary. The quiet street looked peaceful, normal, but my world had been turned upside down, and I knew, with a chilling certainty, that the quiet was about to be broken. The days blurred into a week, then two. The radio remained mostly off. The house was too quiet. I kept the photos of Lily and Tom on the mantelpiece, small acts of defiance against the emptiness. Mark still hadn't called. Sarah hadn't responded. It was complete radio silence from their end, a deliberate cutoff. It felt like a punishment I didn't understand, a sentence delivered without a trial. I started keeping a journal, detailing every interaction I had had with the children, every time I had babysat, every holiday spent together, every conversation with Mark or Sarah about their care. It felt clinical, like building a case, but it also helped me process the memories, holding on to them before they faded or were rewritten by someone else's narrative. I wrote about Lily's first steps in my living room, about teaching Tom how to ride his small tricycle on the sidewalk outside my house, about comforting Lily after a scraped knee, about the shared laughter over a spilled glass of milk. These weren't just anecdotes. They were the threads of a relationship, evidence of my presence, my role, my love. I also documented the instances where Sarah's control had felt stifling, where I had felt subtly pushed aside or undermined. The time she had insisted I follow a strict, printed schedule for their nap and feeding times, even though they were toddlers and their routines were flexible. The time she had corrected my way of holding Lily, showing me the proper technique she had read in a parenting book. The time she had brought their own pre-approved snacks to my house, implying that what I had was unsuitable. Individually, these incidents seemed minor, easily dismissed as a new mother's anxiety, but seen collectively, they formed a pattern of control, a gradual erosion of my confidence and my role. And now, the ultimate act of control, the complete denial of acts. I also noted Mark's reactions, or lack thereof, to these moments. His tendency to defer to Sarah, his quiet agreement with her decisions, even when they seemed unreasonable. His silence now felt like the culmination of years of passivity, of choosing his wife's peace over his mother's connection with his children. It was a bitter pill to swallow. I called Carol again. This time I told her everything. The text message, Mark's silence, the empty house. Carol listened patiently, her voice filled with sympathy. "That's just awful," she said. "I can't imagine. They can't just do that, can they?" I explained my research into grandparent visitation rights. "It's complicated," I said. "It depends on the state, on the circumstances. It usually requires showing that there's been a substantial change in circumstances and that visitation is in the best interest of the child. But denying you access completely, that feels like a substantial change," Carol said. "And surely it's in their best interest to see their grandmother." Her words were a lifeline. They validated my feelings, my sense of injustice. She encouraged me to pursue the legal option, to at least talk to a lawyer. "You have to fight for them," she said. "And for yourself. You've earned your place in their lives." Her support gave me a small boost of courage. It was terrifying to think about taking my own son and his wife to court. It felt like an act of war. But the alternative felt like surrender, and I wasn't ready to surrender. Not yet. I spent hours online, searching for family law attorneys in the Raleigh area who specialized in grandparent rights. I read reviews, looked at websites, trying to find someone who seemed both competent and compassionate. It was important to me that the lawyer understood the emotional complexity of the situation, that it wasn't just a legal dispute, but a fight for a relationship, for a family bond. I found a few possibilities and decided to schedule initial consultations. The first call I made, my voice trembled slight as I explained the situation to the receptionist. "My son and daughter-in-law have stopped me from seeing my grandchildren," I said, the words feeling strange and heavy as I spoke them aloud. "I want to know about grandparent visitation rights." There was a brief pause on the other end of the line. "We handle cases like that," the receptionist said, her tone neutral but professional. "I can schedule you for a consultation with one of our attorneys. There is a fee." The practical details brought me back down to earth. This wasn't just an emotional battle, it was a legal one, with costs and procedures and formal language. It felt daunting, like stepping into a foreign country. I scheduled the appointment for the following week. Hanging up the phone, I felt a mixture of fear and determination. I was taking the first step down a path that would undoubtedly lead to more conflict, more pain. But I was also taking back some control. I was refusing to be invisible, to be erased. I walked back to the kitchen, poured myself a glass of water, and looked out the window at the backyard. The swing set I had bought for the children stood empty, swaying slightly in the breeze. It was a poignant reminder of what was at stake. It wasn't just about my feelings. It was about the children, about their right to know and love their grandmother. And that was a right worth fighting for. The consultation was scheduled for Tuesday morning. What used to be pancake and blanket fort day would now be spent in a lawyer's office, discussing how to potentially sue my own family. The irony was not lost on me. It was a grim sign of how far things had fallen. The lawyer's office was located in a modern building downtown, the kind with glass walls and cold steel furniture. It felt sterile, a stark contrast to the warm, messy reality of family life. Mr. Harrison was older, with kind eyes and a patient demeanor. He listened without interruption as I explained the situation, recounting the text, the silence, the history of subtle control. I showed him photos of the children, pictures I had saved on my phone. These are not just children, I said, my voice thick with emotion. They are my grandchildren, my only grandchildren, and they have been taken away from me. Mr. Harrison nodded slowly. It's a deeply difficult situation. I understand, he said. North Carolina law regarding grandparent visitation is complex, but it does exist. Generally, a grandparent can petition the court for visitation if they can demonstrate that they have a substantial relationship with the child and that the parents are denying that relationship. And importantly, that granting visitation is in the best interest of the child. He explained that simply providing childcare wasn't always enough to prove a substantial relationship in the eyes of the law. It required demonstrating a deep, meaningful bond, one that went beyond just being a babysitter. My journal, with its detailed entries about our shared moments, my memories of teaching them, comforting them, simply being present in their lives, suddenly felt crucial. It wasn't just a record of my pain, it was potential evidence of that bond. We discussed the specific requirements under North Carolina General Statute Section 2B1. He explained that I would need to prove that there had been a change in circumstances affecting the children's welfare, the complete denial of access, and that visitation was in their best interest. He cautioned me that the legal process would be adversarial, that it could damage my relationship with my son permanently, and that there was no guarantee of success. The court generally presumes that parents act in the best interest of their children, he explained. You would have to overcome that presumption to show why denying you visitation is actually harmful to the children, not just inconvenient or upsetting for you. This was the hardest part. How could I prove that being denied access to me was harmful to Lily and Tom? They were young, adaptable. They might simply forget about the Tuesdays and Thursdays with Grandma, find new routines. The thought was agonizing. But then I thought about the stability I provided, the unconditional love, the connection their family history to my son's childhood. Was losing that not a form of harm? Mr. Harrison recommended writing a letter to Mark and Sarah, a formal request for visitation, before initiating legal action. It would serve as documentation of my attempt to resolve the issue amicably and would demonstrate to the court that I had exhausted other options. The letter needed to be firm but not accusatory, outlining my request for scheduled visits and expressing my love for the children. Writing that letter was one of the hardest things I had ever done. Sitting at my dining room table, the sunlight pooling around me, I drafted and redrafted, trying to convey my pain and my determination without sounding angry or desperate. I focused on the children, on their well-being, on the bond we shared. I listed specific dates and times I was available, offering to be flexible, to work with their schedule. I mentioned the stability and love I provided, the memories we had made. I ended by stating my hope that we could resolve this as a family, but also indicating that I was prepared to take further steps if necessary. It felt like a formal declaration of war, dressed up in polite language. I knew, deep down, that this letter was unlikely to change their minds. Its primary purpose was legal documentation, but sending it felt like crossing a threshold. Once it was sent, there was no going back. Mr. Harrison reviewed the letter. He made a few suggestions for clarification and tone. We agreed that I would send it via certified mail, requiring a signature so there would be no dispute about whether they had received it. The process felt surreal. I was using legal tools to communicate with my own son. It highlighted the depth of the breakdown in our relationship. The consultation lasted nearly 2 hours. By the end, my head was swimming with legal terms and possibilities. I left the office with a folder full of information, a signed retainer agreement, and a heavy heart. The path ahead was uncertain and daunting, but I no longer felt powerless. I had taken a step, a difficult, painful step, but a step nonetheless. That evening, I sat in my quiet living room, looking at the empty space where the children used to play. The plastic dinosaur still stood on the mantelpiece. I picked it up, held it tightly for a moment, then placed it back down. This was about more than just dinosaurs and blanket forts. It was about family, about love, about fighting for what was right. And I was ready to fight. The certified letter went out the next day. The tracking number felt like a leash connecting me to an inevitable confrontation. The notification that the certified letter had been delivered arrived 2 days later. A small printed card in my mailbox. It had been signed by Sarah. My heart pounded when I saw it. They knew they had received my formal plea, my attempt at reconciliation before legal action. The wait for their response was agonizing. Every time the phone rang, I jumped. Every email notification sent a jolt through me. Silence, just like before. A deliberate, calculated silence that screamed rejection louder than any words could have. After a week with no response, I contacted Mr. Harrison. They received the letter, I told him. There's been no contact. He wasn't surprised. That's often the case, he said. It demonstrates to the court that you attempted to resolve this amicably. Now, we proceed with filing the complaint. Filing the complaint. The words sounded so formal, so cold. It meant initiating a lawsuit against my son and his wife. There was no turning back now. The process began. Mr. Harrison's office drafted the complaint, detailing the history of my relationship with the children, the sudden denial of access, my attempts to resolve it, and my request for court-ordered visitation. It cited the relevant North Carolina statutes. I had to review it, sign sworn affidavits, confirming the truth of the statements. Reading the document was surreal. My life, my relationship with my family, reduced to legal paragraphs and numbered points. It felt clinical and deeply personal at the same time. We filed the complaint with the court in Wake County, where Carrie is located. The papers had to be formally served on Mark and Sarah. Mr. Harrison explained the process. A sheriff's deputy or a private process server would deliver the documents to their home. It felt almost invasive, like sending a stranger to their doorstep with a declaration of war. I dreaded that moment, knowing the shock and anger it would likely cause. But it was necessary. It was the formal beginning of the legal fight. The tension in my house was palpable, even though I was the only one in it. I started having trouble sleeping. My mind raced with possibilities, with fear of retaliation, with worry about the children. How would Mark and Sarah explain this to them, if they explained it at all? Would they turn the children against me? The thought was unbearable. I found myself retreating into myself. My friend Carol called, offering support, but I found it hard to talk about it. The legal process felt so isolating, so focused on facts and procedures rather than the messy, heartbreaking reality of a family torn apart. I started going for long walks in the mornings, through the quiet streets of my neighborhood. The rhythm of walking helped to clear my head, to ground me in the physical world when my emotional world felt so chaotic. I would walk past houses with children's toys in the yard, swing sets, bicycles, and my chest would ache with longing. I saw other grandparents interacting with their grandchildren at the park, at the grocery store, and it felt like looking into a different reality, a reality I was being denied. During this time, I gathered more documentation, photos, cards the children had made me, emails about scheduling visits from years past, anything that could demonstrate the depth and consistency of my relationship with Lily and Tom. My journal became a crucial tool, a repository of memories and observations. It wasn't just about proving my case, it was about preserving my own truth, my own history with the children. I found an old photo album from Mark's childhood. I sat for hours looking through it, remembering when he was small, when our relationship was simple, loving, uncomplicated. It was hard to reconcile the image of that little boy with the man who was now effectively shutting me out of his life, the man I was preparing to face in court. It highlighted the painful chasm that had opened between us, a chasm that Sarah seemed to have widened and solidified. The service of the papers happened on a Thursday afternoon. Mr. Harrison's office called to inform me it had been done. There was no immediate response from Mark or Sarah, but I knew they had received them. The ball was officially in their court. The weight of that knowledge settled over me. The quiet fight was now public, formalized, irreversible. I spent that evening alone, the silence of the house feeling heavier than ever. I looked at the empty swing set in my backyard, illuminated by the setting sun. It stood as a silent witness to the life I had shared with my grandchildren, a life that was now in question, subject to a legal battle. The first step had been taken. The lawsuit was filed. The fight had begun. It was a daunting prospect, filled with uncertainty and potential heartbreak. But there was also a flicker of something else, a sense of purpose, a quiet determination. I was no longer just reacting to Sarah's actions. I was acting, asserting my right, fighting for my place. The quiet determination solidified into resolve. Whatever came next, I would face it. The initial response from Mark and Sarah arrived formally, through their attorney. They had retained counsel, as expected. Their response to the complaint was a denial of my claims and a request for the court to dismiss the case. It was a cold, legal document, devoid of any personal emotion, yet it attacked the very heart of my connection with the children. They disputed the depth of my relationship with Lily and Tom, characterizing my time with them primarily as paid childcare or occasional babysitting, minimizing the emotional bond. They claimed that their decision to deny me visitation was based on their parental rights and their determination of what was in the children's best interest, implying, without stating explicitly, that my presence was somehow not in their best interest. The document felt like a series of calculated stabs designed to undermine my credibility and my relationship with my grandchildren. It was painful to read their formal denial of the love and connection I felt was so evident. It felt like they were trying to rewrite history to diminish the years of shared moments and deep affection. Mr. Harrison explained that this was a standard legal maneuver, a formal denial that set up the issues for the court to decide. But knowing it was standard didn't lessen the sting. It was their official position put into writing. Their attorney requested discovery, the formal exchange of information and evidence. This meant depositions, interrogatories, requests for documents. It meant delving into the details of my life, my relationship with Mark and Sarah, my interactions with the children, all under legal scrutiny. The prospect was daunting. Having to answer formal questions about my parenting of Mark, my relationship with Sarah, even my financial situation felt invasive and irrelevant to my love for my grandchildren. But Mr. Harrison assured me it was necessary to build our case and counter their claims. The most hurtful part of their response was the subtle implication that I was somehow detrimental to the children. There were veiled references to parental boundaries and avoiding confusion for the children, suggesting that my role somehow complicated things for them. It was a deliberate distortion of the truth, a way to frame their denial of access as a responsible parenting decision rather than a punitive or controlling act. I spent hours with Mr. Harrison preparing for my deposition. He coached me on how to answer questions truthfully, but concisely, to avoid getting drawn into emotional arguments, to stick to the facts. He warned me that their attorney would likely try to provoke me, to make me seem unstable or overly emotional. It was a constant effort to maintain my composure, to remember that this was a legal battle fought on paper and through formal questioning, not an emotional plea for my son's understanding. We reviewed my journal entries, my photos, the letters and cards. These small personal items became exhibits, evidence in a court case. It felt strange and sad to see a child's drawing labeled as Exhibit C. The formal nature of the proceedings highlighted the chasm between the legal process and the human emotion driving it. The court system, designed to resolve disputes, seemed ill-equipped to handle the nuances of family relationships, the silent betrayals, the years of unspoken tension. The battle wasn't just for visitation rights. It was for my dignity, for my place in my family's history, for the recognition of my love and my role as a grandmother. The process of gathering and reviewing evidence brought up painful memories, not just of recent events, but of earlier times when Sarah's control began to assert itself. I recalled family dinners where Sarah subtly steered conversations away from topics I raised, or when she made decisions about holiday plans without consulting me, simply announcing them as a fait accompli. These smaller slights now felt significant, part of a larger pattern leading to this ultimate exclusion. It was a pattern I hadn't fully recognized or acknowledged at the time, always prioritizing peace over confrontation. Now, confrontation was unavoidable. The legal battle forced me to confront these patterns, to see the situation clearly for what it was, a deliberate attempt to marginalize me. The tone of the legal documents was a stark contrast to the quiet, subtle ways Sarah had exerted control in the past. There was no subtlety here. It was a direct legal assault on my relationship with my grandchildren. Mr. Harrison explained the next steps: formal discovery, potentially mediation, and ultimately, if we couldn't reach an agreement, a hearing before a judge. Each step felt heavier than the last. The cost, both financial and emotional, was mounting. But the alternative, giving up, felt like a betrayal of myself, of my grandchildren, of the bond we shared. There was a moment, sitting alone in my living room, looking at the silent phone, the empty house, when the weight of it all felt almost too much to bear. The prospect of facing Mark and Sarah, their attorney, the judge, and having to defend my love, my role, felt overwhelming. But then I would look at the photos on the mantelpiece, at Lily's bright smile, at Tom's mischievous eyes, and the determination would resurface. This wasn't just for me, it was for them. They deserved to know their grandmother. They deserved the love and connection I offered, and I would fight for them. The discovery process was grueling. Interrogatories arrived, pages of detailed questions about my life, my income, my health, my relationship with my son and daughter-in-law, the specifics of every time I had spent with the children, who was present, what we did, who paid for what. It felt invasive and demeaning, as if my worth as a grandmother was being measured by these bureaucratic questions. I spent hours filling out the responses with Miss Harrison recalling details I hadn't thought about in years. Every visit, every conversation, every gift given, every trip taken together. It was like dissecting the entirety of my relationship with the children, pulling it apart piece by piece for legal scrutiny. Their attorney also requested copies of all communication texts, emails, letters between me, Mark, and Sarah. This was where Sarah's original text message denying access became a key piece of evidence. My carefully worded reply, Mark's unanswered voicemail, my subsequent attempts to reach out, all of it was documented, proving my efforts to maintain contact and their deliberate refusal. It was a stark contrast to the formal denial in their legal response. One minute, they were stating in court documents that they were acting in the children's best interest. The next, their own communication, or lack thereof, showed a cold, summary dismissal. The deposition was scheduled for a few weeks later. Mr. Harrison prepared me thoroughly, but the anxiety was immense. Sitting across a table from their attorney, with a court reporter transcribing every word, felt like being on trial. Their attorney was polite but relentless, questioning my motives, my interactions with the children, even trying to find inconsistencies in my recollections. They asked about specific incidents, dates, times, trying to poke holes in my narrative. They asked about my parenting of Mark, implying that perhaps I had been an overbearing or difficult mother, suggesting that might explain Sarah's actions. It was a painful line of questioning, dredging up old insecurities and disagreements. I answered calmly, truthfully, focusing on my love for the children and my desire to be a positive presence in their lives. I described our routines, our games, the simple joys of our time together. I spoke about the stability and unconditional love I offered, things that are hard to quantify in a legal setting, but felt essential to the children's well-being. There was a moment when their attorney asked, in a seemingly innocent tone, about a time Lily had cried when it was time to leave my house. Isn't it true that she often became upset when you left? He asked. I confirmed that sometimes she did, as many young children do when leaving a place they enjoy. And isn't it possible, he continued, his voice low, that this upset was a sign of instability caused by the transitions? That perhaps your presence, while you may have believed it was positive, was actually creating anxiety for the child? The question hung in the air, a sickening twisting of a normal, childlike reaction. It was a deliberate attempt to plant doubt, to frame my relationship as harmful. I looked him directly in the eye and said, calmly, children often cry when they leave a place where they feel loved and happy. It was a sign that she enjoyed her time with me, not that it was harmful. Mr. Harrison gave a subtle nod. It was important not to get defensive, not to let their narrative take hold. The deposition lasted for hours. By the end, I was emotionally exhausted, my voice hoarse, but I felt a sense of quiet accomplishment. I had answered their questions honestly, maintained my composure, and defended the truth of my relationship with my grandchildren. I hadn't crumbled. I hadn't given them the emotional reaction they seemed to be seeking. After my deposition, Sarah was deposed, and then Mark. I wasn't present for theirs. But Miss Harrison received the transcripts. Reading them was incredibly difficult. Sarah's testimony was cold, measured, and full of justifications for her actions. She spoke about her parenting philosophy, the importance of routine and consistency, and how my involvement, in her view, disrupted that. She reiterated the idea that my presence created confusion for the children. She described perceived minor disagreements or differences in parenting styles as significant conflicts, painting a picture of me as difficult, overbearing, and unwilling to respect her boundaries. It was a distorted, unrecognizable portrait of myself and our interactions. It was clear she had built a narrative, a justification for cutting me out, and she was sticking to it. Mark's deposition was shorter, less assertive. He seemed uncomfortable, hesitant. He largely deferred to Sarah's statements, agreeing that their decision was what was best for the kids. He admitted that he hadn't spoken to me about the decision before Sarah sent the text, and that he hadn't responded to my subsequent attempts to contact him. His testimony revealed his passivity, his unwillingness to challenge Sarah, and his apparent acceptance of her narrative. It was painful to see his lack of agency, his quiet complicity in the decision to cut me off. Reading his words, I realized the depth of his detachment, the extent to which he had allowed his wife to control this part of his life, his relationship with his mother and his children. The legal process, cold and formal, had forced them to articulate their reasons, their justifications, and in doing so, it had laid bare the emotional landscape of our family, the power dynamics, the resentments, the quiet betrayal. The mountain ahead still seemed steep, but I felt a newfound resolve. I had seen their cards, their strategy, and I was more determined than ever to fight for the truth, for the connection I shared with Lily and Tom. The discovery phase continued, an endless exchange of paper, requests, and response. We received documents from Mark and Sarah's attorney, school records for Lily, pediatrician notes, calendars showing the children's schedules. There was nothing in these documents that suggested my presence had ever been harmful or disruptive to the children's well-being. They were healthy, doing well in school, well-adjusted. It underscored the flimsiness of Sarah's stated reasons for denying access. It seemed her decision was based solely on a desire for control, not on any legitimate concern for the children. We submitted our evidence, my journal entries, the photographs, the cards and drawings from the children, the certified mail receipt for the letter I had sent, the transcripts of our texts and emails showing their abrupt cutoff. This collection of personal items, now exhibits in a legal case, told the story of a loving, consistent relationship deliberately severed. Mr. Harrison believed we had a strong case for establishing a substantial relationship and demonstrating a change in circumstances. The biggest challenge remained proving that visitation was in the children's best interest and overcoming the legal presumption that parents act in that interest. We discussed strategies for mediation. Many grandparent visitation cases are settled out of court, often through mediation, to avoid the emotional and financial costs of a full trial. Mr. Harrison suggested it was worth trying, both to show the court our willingness to compromise and because it might lead to an agreement that was less adversarial than a court order. I agreed, though the thought of sitting in a room with Mark and Sarah, facilitated by a neutral third party, filled me with dread. The mediation session was scheduled for a Saturday at the courthouse, in a private conference room. Mr. Harrison was with me. Mark and Sarah were in a separate room with their attorney. The mediator, a kind but no-nonsense woman, shuttled between the rooms, carrying offers and counteroffers. It felt absurd, discussing access to my grandchildren through a third party, like a business negotiation rather than a family matter. We started with my offer: regular bi-weekly visits, alternating holidays, communication rights, phone calls, video calls. Their initial counteroffer was minimal, supervised visits only, perhaps once every few months, with no independent communication. It was insulting, a clear indication that they were still trying to limit my access as much as possible, to maintain control. The mediator explained that their position seemed unreasonable given the evidence of my past involvement and lack of any proven harm to the children. She encouraged them to consider the long-term impact of denying the children a relationship with their grandmother. Hours passed. The back and forth was emotionally draining. Every offer, every refusal, felt like a judgment on me, on my relationship with the children. Sarah, through the mediator, maintained her stance that unsupervised visits were not in the children's best interest, citing vague concerns about disruption to their routine. Mark remained largely silent, letting Sarah and their lawyer speak for him. It was frustrating and heartbreaking to see my son so passive, so seemingly detached from the reality of what was happening. At one point, the mediator brought a message from their room. They were willing to consider unsupervised visits, but only for short durations and infrequent. It felt like a small concession, but still far from what I believed was appropriate or in the children's best interest, or reflective of our prior relationship. As the day wore on, the offers became slightly more generous, but the core issue of control remained. They wanted to dictate every aspect of the visits, to retain the power to cancel or change plans at their whim. I needed a schedule that was reliable, consistent, something the children could count on. The idea of constant uncertainty of visits hanging precariously on Sarah's mood was unacceptable. Late in the afternoon, the mediator delivered their final offer. It was slightly better than the previous ones, proposing unsupervised visits one Saturday per month, plus 1 week during the summer, and some holiday access. It was still less than half of the time I had spent with them before the cutoff, and it came with conditions, stipulations about communication and parental notification. It felt like a compromise, but one that still left them in control, that still treated my time with the children as a privilege granted, rather than a relationship to be nurtured. Mr. Harrison advised me to consider it. It was a formal offer, something a judge would look favorably upon as a good faith effort to settle. But looking at the offer on the table, I felt a deep sense of dissatisfaction. It wasn't just about the quantity of time, it was about the quality, the spontaneity, the feeling of being a natural part of their lives, not a scheduled appointment. It felt like accepting a diminished role, one that still allowed Sarah to maintain significant control. I looked at Mr. Harrison. It's not enough, I said quietly. It's not about the hours on paper. It's about the relationship. And this doesn't restore the relationship. It just creates a limited, controlled version of it. The mediator returned to their room. We waited. The silence in our room was heavy. After a few minutes, the mediator returned. They are not willing to offer more at this time, she said, her voice regretful. It seems we have reached an impasse. Mediation had failed. We were heading towards a hearing, towards a judge deciding the fate of my relationship with my grandchildren. There was no more hiding behind lawyers and mediators. It would come down to presenting our case in court, to arguing for the children's need for a grandmother in their lives. Mediation's failure meant the case would proceed to a hearing before a judge. This was it, the formal presentation of evidence, witness testimony, legal arguments, the culmination of months of preparation, anxiety, and emotional strain. The thought of testifying in court, facing my son and daughter-in-law from across the room, daunting. Mr. Harrison spent considerable time preparing me, going over potential questions, rehearsing my testimony, reinforcing the importance of staying calm, focused, and credible. Our strategy was to present a clear picture of the substantial relationship I had with Lily and Tom, demonstrate the abrupt and unjustified nature of their parents' cutoff, and compellingly argue that restoring visitation was essential for the children's emotional well-being and sense of family identity. We would highlight the inconsistencies in Sarah's reasons for denying access, pointing out that there was no evidence of harm or disruption caused by my prior involvement. We would emphasize the benefit to the children of having a stable, loving relationship with their grandmother, a connection to their paternal heritage. I would testify about the routine we had, the activities we shared, the conversations we had, the love that flowed between us. I would talk about specific memories, moments that illustrated the depth of our bond. It felt strange and vulnerable to lay bare these private, cherished moments for public scrutiny, for a judge to evaluate and weigh. We also prepared potential witnesses. My friend Carol agreed to testify about what she had observed of my relationship with the children and the distress I had suffered from the cutoff. Mr. Harrison explored calling other family members, but many were reluctant to get involved, not wanting to take sides in such a painful dispute. This reinforced the sense of isolation the lawsuit had created within the broader family. Some family members had expressed sympathy privately, but few were willing to offer public support in court. It was a stark reminder of the power dynamics at play, how fear of alienating Mark and Sarah kept people silent. The date for the hearing was set. As it approached, the tension became almost unbearable. Sleep was difficult. Appetite waned. Every noise, every car driving by, made me jump. My focus narrowed to the upcoming court date. The rest of the world faded into the background. I reviewed my journal repeatedly, rereading my own words, anchoring myself in the truth of my experiences. The day of the hearing arrived. The courtroom was formal, intimidating. The judge sat elevated, a figure of authority. Mark and Sarah were there with their attorney, sitting across the room. I avoided making eye contact. Seeing them there in that setting felt profoundly unnatural, a culmination of something that should never have reached this point. Mr. Harrison presented our case, outlining the history, the law, and our arguments. Then, it was my turn to testify. I walked to the witness stand, swore to tell the truth, and sat down. My hands were trembling slightly, but I focused on my breathing, on Mr. Harrison's calm presence. He began questioning me, guiding me through my testimony. I spoke about the birth of each child, the joy they brought, my eagerness to be involved. I described the routine childcare I provided, not just as a service, but as dedicated time spent nurturing a relationship. I talked about reading stories, teaching them to bake, going to the park, the simple, everyday moments that built our connection. I showed the photos, the children's artwork, explaining the context of each piece. I read excerpts from my journal, detailing specific conversations or activities with Lily and Tom, demonstrating the consistent, loving nature of our bond. I spoke about the sudden text message, the lack of explanation, the subsequent silence. My voice was steady, though laced with emotion. I tried to convey not just the facts, but the depth of my love, the pain of the separation, the sincerity of my desire to be a part of their lives. Then came cross-examination by their attorney. He asked probing questions, attempting to portray me as interfering, as having boundary issues, as exaggerating the depth of my relationship with the children. He brought up minor disagreements I'd had with Sarah over the years, taking them out of context and presenting them as evidence of a difficult relationship. I answered each question truthfully, calmly, correcting misrepresentations without becoming defensive. I focused on the children, reiterating that my actions were always motivated by love and concern for their well-being. After my testimony, Carol testified, speaking about my character and her observations of my relationship with the children. Mr. Harrison then presented other evidence, including the certified mail receipt and the transcripts of our communication, highlighting the abrupt cutoff. Mark and Sarah and their attorney presented their case. Sarah testified, repeating the narrative she had laid out in her deposition, focusing on her perception of my interference and the importance of her parental authority. She spoke about wanting to raise her children according to her own principles, free from what she perceived as outside influence. Her tone was cool and controlled. Mark also testified, reiterating his agreement with Sarah's decision and his belief that it was best for the children. He seemed uncomfortable on the stand, avoiding my gaze. Their attorney argued that parents have a fundamental right to raise their children as they see fit, and that a grandparent should not be allowed to interfere with that right without clear evidence of harm to the children. The hearing lasted for 2 days. It was emotionally exhausting, a constant oscillation between presenting my truth and hearing it distorted by others. The judge listened attentively, taking notes. At the end of the hearing, both attorneys made their closing arguments, summarizing their points and urging the judge to rule in their favor. Mr. Harrison argued that the total denial of access, without a legitimate reason, was harmful to the children, depriving them of a significant loving relationship that had been a stable part of their lives. He argued that I had proven a substantial relationship and that restoring visitation was clearly in the children's best interest. Their attorney argued that parents' rights were paramount and that I had failed to demonstrate that their decision was harmful to the children or that visitation was essential to their welfare. The case was over. All that was left was to wait for the judge's decision. The waiting felt endless, suspended in uncertainty after months of active struggle. Waiting for the judge's decision felt like an eternity. Every day was filled with anticipation and dread. I found it difficult to focus on anything else. The hearing replayed in my mind. Every question asked, every answer given, every glance exchanged across the courtroom. Had I said the right things? Had I conveyed the depth of my love and the injustice of the situation clearly enough? Had the judge understood? Harrison cautioned me that it could take several weeks or even months for the judge to issue a written order. He explained that the judge would carefully consider all the evidence, the testimony, and the relevant law before making a decision. He remained cautiously optimistic, believing we had presented a strong case for establishing a substantial relationship and arguing for the children's best interest. But he also reminded me that grandparent visitation cases are challenging, and the outcome is never guaranteed. The legal standard of proving that denying visitation is harmful to the children and that granting it is in their best interest is a high bar to clear, as parents' rights are strongly protected. I tried to return to some semblance of routine. I went for walks, worked in the garden, met Carol for coffee, but the quiet of the house was still heavy, the absence of the children a constant ache. I avoided places we used to go together, the park, the local library, the ice cream shop. It was too painful. I looked at the photos on the mantelpiece less often, not because I loved them less, but because they were a reminder of what was at stake, of the potential loss. One afternoon, Mark called. It was the first time we had spoken, really spoken, since before the text message. His voice was strained, hesitant. He didn't apologize for the silence, didn't mention the lawsuit directly, but he asked how It was a brief, awkward conversation, circling the edges of the unspoken conflict that had consumed our lives. He mentioned that the legal process was hard on everyone. I agreed, my voice quiet. He didn't offer any explanation for Sarah's actions, or his own. It was as if the court hearing had happened in a parallel universe, the emotional reality of it too difficult for him to acknowledge. It was a small crack in the wall of silence, but it didn't bridge the chasm. It felt like a moment of tentative contact, born more out of shared strain than genuine reconciliation. The wait continued. The legal fees were mounting, adding another layer of stress. I had dipped into my savings, money I had set aside for retirement, for emergencies. It was a heavy financial burden, but I viewed it as an investment in my family, in the future relationship I hoped to have with my grandchildren. The principle felt worth the cost, but the reality of it was daunting. Then, several weeks after the hearing, Mr. Harrison's office called. The judge's order had been issued. My heart leaped into my throat. I have the order here, Mr. Harrison said, his voice calm. The judge has ruled, he began to read. The judge had acknowledged the difficult nature of the case and the sensitive balance between parental rights and the importance of grandparent-grandchild relationships. The order reviewed the evidence presented, including my testimony, the journal entries, the photos, and the parents' testimony. The judge found that I had indeed demonstrated a substantial relationship with Lily and Tom, a bond that went beyond casual contact or childcare. The order noted the abrupt and unexplained nature of the parents' decision to deny access, finding that it constituted a change in circumstances that impacted the children. Crucially, the judge ruled that, based on the evidence presented, it was in the best interest of Lily and Tom to have a relationship with their grandmother. The judge found that denying them this relationship was detrimental to their welfare, depriving them of a source of love, stability, and connection to their family heritage. The order granted me visitation rights. It didn't grant every single thing I had asked for, but it established a clear, consistent schedule. Unsupervised visits twice a month, alternating weekends, plus specific time during holidays, and a week in the summer. It also included provisions for communication, allowing me to call and video chat with the children at reasonable times. It was a victory, not just legally but emotionally. The court had affirmed the value of my relationship with my grandchildren. It had validated my fight. Hearing Mr. Harrison read the order, I felt a wave of relief wash over me, followed by a quiet sense of vindication. It hadn't been easy. It had been painful, expensive, and emotionally draining. It had strained my relationship with my son to the breaking point. But I had stood up for myself, for my grandchildren, for the principle that love and family connection matter and cannot simply be discarded at will. The court order was a legal document, cold and formal, but it represented the restoration of something vital, something human. It meant I would see Lily and Tom again. The judge's order was a legal document, granting me scheduled visitation. It felt both like a victory and a heavy responsibility. The order stipulated the specific dates and times for my visits, removing the uncertainty and control that had been wielded against me. It was a framework, a legal structure imposed upon a broken family dynamic. The first scheduled visit approached. It felt strange having it dictated by a court order rather than a simple family arrangement. Mr. Harrison had sent a copy of the order to Mark and Sarah's attorney. There was no direct communication from them to me about the logistics, only through the formal channels of our lawyers. It underscored the lingering distance, the lack of emotional repair despite the legal resolution. The pickup was set for a Saturday morning. I drove to their house in Cary, my hands tight on the steering wheel. It was the first time I had been there since before the cutoff, since the text message that had shattered our family. Pulling into the driveway felt surreal. The house looked the same, ordinary, yet everything felt different. I walked up to the front door and rang the bell. The door opened after a moment, and Sarah stood there. Her expression was neutral, unreadable. There was no warmth, no hostility, just a cool, formal acknowledgement of my presence. "They're ready," she said, her voice flat. Lily and Tom appeared behind her, dressed and ready. Their faces were hesitant, unsure. It had been months since they had seen me regularly. Lily, who was now 4, looked at me with wide, curious eyes. Tom, almost 3, clutched a small stuffed animal. Grandma? Lily said, her voice quiet. Lily, Tom, I said, my voice thick with emotion I struggled to keep in check. It's Grandma. They stepped forward slowly. I knelt down, opening my arms. They came to me, hesitant at first, then Lily threw her arms around my neck. Tom clung to my leg. I held them tightly, tears welling in my eyes. It was a moment of pure, unadulterated love, a stark contrast to the legal battle that had brought us here. Sarah stood in the doorway, watching, her expression still neutral. There was no invitation inside, no attempt at conversation. The exchange felt transactional, a handover dictated by a court order. I stood up, holding Lily's hand, Tom staying close by my side. We'll be back by 5, I said, addressing Sarah. The order specifies 6, she replied, her voice clipped. Right. The order. Right, I corrected myself. 6. We'll be back by 6. We walked to my car. As we drove away, I glanced in the rearview mirror. Sarah was still standing in the doorway, watching. It was a silent farewell, devoid of warmth. In the car, the children were quiet at first, adjusting to being with me again. I talked to them gently, asking about their toys, their friends, simple things. Slowly, tentatively, they began to open up. Lily told me about preschool. Tom chattered about his dinosaur toys. The familiar rhythm of being with them began to return. We went to the park, a different one this time, not wanting to revisit the exact place that held memories of the recent past. We played on the swings, went down the slide, built sandcastles. Their laughter filled the air, a sound I had missed desperately. It was healing. Being with them felt natural, right? The legal fight faded into the background, replaced by the simple joy of their presence. We had lunch, read some books, watched a short cartoon. It wasn't exactly like the old days, but it was a start. The bond was still there, maybe a little stretched and tested, but resilient. The court order had provided the necessary space, the opportunity for this connection to be rekindled. It hadn't healed the rift with Mark and Sarah, and I knew that relationship would likely remain strained, perhaps permanently altered by the lawsuit. The communication continued to be minimal, formal, often through lawyers. But my focus had shifted. It was no longer about winning a legal battle or gaining their approval. It was about maintaining my relationship with Lily and Tom, about being a stable, loving presence in their lives, something the court had affirmed was their right to have. As the day drew to a close, I felt a sense of quiet accomplishment, not from winning in court, but from simply having the opportunity to be with them again. The legal battle had been a means to an end, a necessary fight for access. The true victory was this day, the laughter, the connection, the simple joy of being Grandma. Driving them back to their house, the setting sun casting long shadows, I felt a sense of peace I hadn't felt in months. It wasn't the peace of a perfectly reconciled family, but the peace of having fought for something important and gained a measure of what was lost. I pulled into their driveway at exactly 6 o'clock, adhering strictly to the order. Sarah was waiting at the door. The handover was brief, polite. They were wonderful, I said, looking at the children. Lily hugged me goodbye, holding on for a moment longer this time. Tom waved. As I drove away, I didn't look in the rearview mirror. My focus was forward, on the road ahead, on the next scheduled visit. The house I returned to in Cary still felt quiet, but it was a different kind of quiet now. Not the oppressive silence of absence and despair, but the quiet of a battle fought and a measure of peace attained. My home was my own space again, a sanctuary. The photos of Lily and Tom on the mantelpiece no longer felt like ghosts of a lost past, but promise of a future I had fought for and won, not with aggression, but with quiet resolve and the unwavering belief in the power of love and family connection. The legal chapter was closed, the fight was over, but my relationship with my grandchildren, had been given a chance to grow again on terms that were legally protected. It wasn't perfect, but it was real. It was mine.